postponed to today for judgment. And the following is the judgment. I'll read it out. Rhoda Jones, a Christian meditator, in her article titled Depression and Negative Thoughts, said the following regarding the power of thoughts and words. Watch your thoughts, they become words. Watch your words, they become actions. Watch your actions, they become habits. Watch your habits, they become character. Watch your character, for it become your destiny, end of quote. As recent as 8 February 2022, in the House of Commons of the United Kingdom, while rebuking the Prime Minister, the British Prime Minister Boris Johnson, the Speaker, Sir Lindsay Hoyle, set the record straight when he said the following, open quote, "Our words have consequences, and we should always be mindful of the fact," end of quote. The court is seized with a defamation claim arising from a video clip recorded and distributed on social media where slanderous affirmations were made against the plaintiff. The plaintiff resultantly instituted action and claimed an amount of 350,000 Namibian dollars plus interest and costs on a punitive scale of attorney and own client. Plaintiff further prayed for an order declaring statements made in the video clip as false and further seek an order to direct the defendant to unconditionally retract the said statements and unreservedly apologize to the plaintiff within 5 days of the court order for the harm caused. The claim is defended. The plaintiff is Mrs. Monica Geingos, born Kalondo, an adult female and the First Lady of the Republic of Namibia by virtue of her marriage to Dr. Hage G. Geingos, the President of the Republic of Namibia. She's a lawyer by training and a business executive in the field of private equity. She's the founder and chairperson of One Economy Foundation, a foundation which she established with the main objective to alleviate people out of poverty and fight against economic inequality in Namibia. Her role in the economy of Namibia received local and international recognition. She resides at Casa Rosalia, KZ 2021, Airport Road, Avis in Windhoek, Republic of Namibia. The defendant is Mr. Abed Linovene Bishop Hishono, a Namibian adult male teacher at Ilao Primary School in Ohangwena region, and a mobilizer of the Independent Patriots for Change, IPC, a political party in the Republic of Namibia. The plaintiff is represented by Mr. S. Namanje, while the defendant is unrepresented and acts in person. The pleadings. The plaintiff alleged that between 12 and 16 February 2021, the defendant authored and featured in a video recording which was widely circulated, where false allegations and insinuations were made about the plaintiff to the effect that she was clandestinely involved in the collapse of Air Namibia through her business interests with West Air Aviation, where she has an interest and or is a shareholder and was instrumental in its establishment. B, that she corruptly influenced decisions regarding the liquidation of Air Namibia in order to protect her economic interest. C, that she is a girlfriend and has an adult son with one Hatukulipi who is in police custody, and that the said Hatukulipi arranged and procured the plaintiff's marriage to the President of the Republic of Namibia. The particulars of claim quote the content of the said video recording, which was made in Oshwambo language and translated to English by song translator verbatim as follows, open quote. Traffic by road, mode of transport by road, rail, marine and air. As our mode of traffic by air in Namibia, we have Namibian airplanes and say a Namibian airline. A Namibian airline which fly visitors across, in and out of Namibia, and thereby generating an income. In between there, when this president of Nacional came to power, the very one who's under discussion here, there were voyages among the Namibian airline, and some of these airlines belongs to the spouse of the president, it seems. Know that the president was availed a wife by Hatukulipi. Hatukulipi is the one who supplies the president a spouse. The very one, the one and only Monica, who is a girlfriend to Hatukulipi, and they even parented a child together, a full-grown son who is over the age of 20 years. And the very same Hatukulipi who presented Monica is a friend to Geingos. How can you be connected by a woman as such to join you, a president and a thief, together? So the airplanes that were flying over there belongs to Monica. A company named West Air was found. Some professionals came together and initiated their company, a voyage company, West Air. For West Air to thrive, they first had to destroy Air Namibia. The state-owned airline, Air Namibia, must be unproductive so that West Air can get customers. The visitors must use West Air aviation flights. And to whom will the money go? It must go to them, the very ones. West Air was established extraordinarily so that Air Namibia can fall. Do you understand that? Watch out. The country is dented. Some does not know that Monica, they hold shares in West Air. West Air is now the airline of choice. All the flights in Namibia are now considered for them. Visitors must come into the country. We need tourism, which brings in much needed revenue to the country. When visitors come to watch our elephants in our country and so forth, for them to come here, they have to fly in. Which belongs to who? It does not belong to Namibia. To whom does it belong? It belongs to West Air. To whom does West Air belong? It belongs to Monica. Whose wife is Monica? She is Geingos' wife. Given to him by who? By Hatukulipi. Where is Hatukulipi? He's in jail. Oh well, welcome to Namibia. That is how things are. That is all I can inform you about for today, so you know. That is where I end for now. Have a blessed weekend. End of court. Plaintiff claims that the above-mentioned statements were intended by the defendant to mean and were understood by persons who acquired knowledge of same that the plaintiff is corrupt, greedy, conspired with others to corruptly and inappropriately collapse the airline Air Namibia, and corruptly use their influence to disadvantage Namibian people. Plaintiff further claims that the said statements are false and defamatory. Defendant had no factual basis to make such allegations, which were meant to injure plaintiff's reputation and dignity. Defendant used his positions of power to legitimize the credence of his false statements. So the plaintiff's testimony went. The distribution of such statements by the defendant gravely injured the plaintiff's reputation and dignity and lowered her esteem in the eyes of the right-thinking members of the Namibian community and others elsewhere who acquired knowledge of such statements, so plaintiff further claims. The defendant in his plea, which was filed with the assistance of his erstwhile legal representatives, Henry Shimutukeni and Company, Incorporated, stated that Henry Shimutukeni and Company denied the allegations regarding the video recording made by the defendant as set out by the plaintiff in the particulars of claim. The defendant proceeded to plead that if it is found that he made and published the innuendos alleged, then he denies that they were intended to mean and that they were understood by persons to whom they were published to mean that there was an improper link between the plaintiff, a public official, and West Air Aviation. This is premised on the allegation that the plaintiff is the First Lady of the Republic of Namibia and a public official with influence on the decisions of government and the state of Namibia, as her office is inextricably linked to the presidency, so the defendant pleaded. The defendant pleaded further that the plaintiff plays an operational role in Stimulus Investments Limited Namibia, Stimulus Investments, where she has an interest, while Stimulus Investments has an interest in West Air Aviation. He further pleaded that the president has been characterized with corruption allegations such as the Fisherot saga. The defendant pleaded in further alternative that if the words allegedly used by the defendant were understood as alleged by the plaintiff, then the statements were not made with intention to injure the plaintiff's reputation and dignity, because such statements concerned a matter of public interest relating to ongoing state corruption. His intention was further to obtain clarity on the activities of the plaintiff as a public office holder, so he pleaded. Issues for determination. In terms of the joint pre-trial report dated 6 July 2021, which was prepared by the parties at a time when the defendant still had legal representation, the content of which was made an order of court on 21 September 2021. This matter was referred to trial on the following relevant issues. A, whether or not the defendant featured in a video widely circulated where slanderous allegations were made against the plaintiff and circulated same. B, whether or not the affirmations made by the defendant in the video were true. C, whether or not the allegations made by the defendant were intended to defame the plaintiff and harm her feelings and dignity. D, whether or not statements made constituted a statement of fact or fake comment regarding a matter of public interest. It is worth mentioning that the pre-trial report further listed agreed facts between the parties, which included the following. One, the fact that the plaintiff is the First Lady of the Republic of Namibia by virtue of her marriage to the President. Two, the accolades of the plaintiff as set out herein above. C, that the allegations made in the video were made towards the plaintiff. With the opportunity presenting itself to address the above-mentioned issues, it is now appropriate to consider, in my view, the evidence laid by the parties. Plaintiff's case. In a quest to prove her case, the plaintiff took to the stand and testified as the sole witness. She testified inter alia that she is the First Lady by virtue of her marriage to the President, a lawyer by training, and an accomplished business executive in private equity with over 20 years in the financial sector. She testified that she is the founder and chairperson of One Economy Foundation, a foundation established to uplift people out of poverty and fight against existing economic inequality. She further stated that her work in various areas of the economy received recognition both domestically in Namibia and internationally. She was also appointed as the UNAIDS Special Advocate for Young Women and Adolescent Girls. Plaintiff testified further that amongst the accolades received, she was awarded the National Honors Most Distinguished Order of Namibia by His Excellency, the former President of the Republic of Namibia, Hifikepunye Pohamba, for a contribution to the socio-economic development of Namibia. She was also inducted into the Namibia Business Hall of Fame. The media publications rated her as one of Africa's top 100 economic leaders. It was her testimony further that before becoming the First Lady in 2015, she was a co-shareholder and managing director of Namibia's largest private equity fund for over a decade, during which period she served on several boards of public and private companies. She served as a member of the President Economic Advisory Council, the governing party's think tank, and the National Council of the Namibia Chamber of Commerce and Industry. She further testified that the defendant, a teacher and a regional mobilizer for IPC in Hangwena region, circulated a video on social media platforms where he made defamatory statements against her. A day before her wedding anniversary, 13 February 2021, she was alerted to the video circulating on social media by another person. At watching the video, she was shocked to see the defendant state with confidence false and defamatory statements about her. She denied the allegations in the video as devoid of any truth and only aimed to injure her good reputation and violate her dignity and that of her family, including her children, who were subjected to public stigmatization. Out of the persons named Hatukulipi in jail, she only knows Mr. James Hatukulipi, who was her schoolmate and a colleague at the university and in the finance field. She had no sexual relationship with Mr. Hatukulipi, neither does she have a child fathered by Mr. Hatukulipi. As somebody she knew, she requested Mr. Hatukulipi, who was in London, to bring along the president's suit to Namibia, which was already paid for. And he brought it. She stated further that no friendship existed between the president and Mr. Tukulepi. She denied owning an airline or West Air and denied a plan to collapse Air Namibia. The allegations of collapsing Air Namibia were made when Air Namibia, an emotive public issue by then, where over 600 employees were due to lose employment, was the topic of the day. She testified that she was a managing director of Stimulus, as I said before, which had an interest in the entity West Air Maintenance and not West Air Aviation, which is a different entity. There was no competition between West Air Maintenance and Air Namibia. At times, West Air Maintenance rendered services to Air Namibia. The interests of Stimulus investments in West Air Maintenance came to an end on 17 February 2011, so she testified. She resigned from being an operational director at Stimulus Investments in 2015 and remained just a director and a shareholder. She testified further that as First Lady, she has no influence in operations of state-owned companies. She testified that after she issued summons against the defendant, he persisted in his conduct by making a statement on his Facebook account that, open quote, meet Abed Hishono, the first man ever to be sued by the First Lady in Namibia, if not in the whole world, end of quote. She further testified that in another Facebook post made after summons were issued, the defendant said, open quote, she must just come, maybe she wants me, end of quote. It was evidence further that she was abused on social media platforms as a result of the allegations made by the defendant. In her view, the defamatory statements were aggravated by the fact that the defendant in his plea sought to injure her name further by suggesting that on account of a marriage to the president alone means that she is corrupt. This was a politically motivated attack on her because of a marriage to the president, just as he distributed the video to score cheap political points to the expense of her reputation and dignity. She stated that the video was aimed at delegitimizing the president and dehumanizing her in the process. She testified further that the defendant's father and her father are good friends, and that she regarded the defendant's father as part of her family to the extent that she contacted the defendant's father and apologized to him for intending to institute these proceedings against the defendant. In cross-examination, the defendant put it to the plaintiff that he apologized to her. The plaintiff responded that the apology was never presented to her and she rejected it as the defendant persisted in his defamatory statements. The defendant further questioned the plaintiff that she had in the past been subjected to several insults, but she only opted to institute action against him out of political motivation. Plaintiff responded that as First Lady, she was indeed subjected to several insults and decided to have a thick skin and absorb such insults. But the defendant became an exception when he involved her children. She decided to protect her children. She further realized that when the president steps down, she'll be 48 years old and may need to return to the private sector while her reputation may have been tarnished. The video was above all extremely degrading, so she said. Defendant's case. The defendant was equally the sole witness for his case. He testified inter alia that in February 2021, after the news of the liquidation of Air Namibia, came to the fore, he wondered where the nation was headed to. He knew that the plaintiff was involved with Fly West Air, and he believed that since Fly West Air was competing with Air Namibia for customers, the demise of Air Namibia would benefit Fly West Air. He video recorded himself thereafter, and thereafter he posted the video clip on a WhatsApp group. He later realized that this information posted was not accurate, after which he retracted the allegations and issued an apology to the plaintiff, circulated widely on social media in the same manner as he made the video. So he claimed. He deleted the initial video and left social groups where people kept circulating the first video. The defendant further testified that the plaintiff has a child fathered by Mr. James Hatukulipi, who is the president's friend, as this information was widely circulated. He proceeded to state that it was all over the newspapers, that the president was named in the Fish Road documents. He referred to the said information as national hearsay. He testified further that he regrets publishing the video without accurate information, hence he issued the apology to the plaintiff and her family. In cross-examination by Mr. Namanje, the defendant conceded that he is a leader in his class, and politically he is a leader during political campaigns. When asked as to what caused him to record the video, the defendant stated that it was due to the collapse of Air Namibia. He confirmed, when further questioned by Mr. Namanje, that he had no independent knowledge of the correctness of the allegations made in the video. Pressed further to question the purpose of the video, it was put to the defendant that the allegation that Mr. Hatukulipi availed the plaintiff as a wife to the president is unrelated to the demise of Air Namibia. The defendant responded that on that score, he intended to inform his friends and the public that Mr. Hatukulipi availed a wife to the president. This information, according to the defendant, emanated from social media, which he was simply repeating. The defendant repeatedly stated that all that he said in the video was to repeat the rumors circulating in the country. He said he fell victim to rumor mongering. He also stated that his intention to record the video was to inform the people of the content of the video. When asked that in the video he suggests that the plaintiff was a girlfriend to Mr. Hatukulipi and that the two had a child together, the defendant answered in the affirmative and said that this was based on the rumor which he had, but he could also not state where the rumor originated from. It was his testimony that he knew that people were angry about the liquidation of Air Namibia And as a politician, he opted to act by recording the video and shared with one group on social media. He, however, did not put a caveat to prevent the further circulation of the video to unintended persons. When questioned that by failing to verify the allegations made in the video, the defendant was reckless, he conceded that he was indeed reckless in respect of the facts and information to base his allegations, and that if he was careful, then he would not have made the allegations in the video. On the question of injury to the plaintiff's reputation and dignity, the defendant said that the video was not intended for the eyes of the plaintiff to see. In the analysis, Damascus JP in Danneker versus Leopard Tours Car and Camping Hire CC restated the tried legal principle that he who alleges must prove his allegation on a balance of probabilities in order to succeed, in order to sustain the claim in the following manner. Open court. It is tried that he who alleges must prove. A duty rests on the litigant to adduce evidence that is sufficient to persuade a court at the end of the trial that his or her claim or defense, as the case may be, should succeed. A three-legged approach was stated in Pillar versus Krishna as follows. The first rule is that the party who claims something from another in a court of law has the duty to satisfy the court that it is entitled to the relief sought. Secondly, where the party against whom the claim is made sets up a special defense, it is regarded in respect of that defense as being the claimant. For the special defense to be upheld, the defendant must satisfy the court that it is entitled to succeed on it. As the learned authors Zaffert in South African Law of Evidence argue, the first two rules have been read to mean that the plaintiff must prove his or her claim unless it is admitted, and then the defendant his plea, since he is the plaintiff as far as that goes. The third rule is that he who asserts proves and not he who denies. A mere denial of facts, which is absolute, does not place the burden of proof on he who denies, but rather on the one who alleges. As was observed by Davis AJA, each party may bear a burden of proof on several and distinct issues, save that the burden on proving the claim supersedes the burden of proving the defense. End of quote. At the backdrop of the above established principle, I venture into the analysis of the evidence presented. It should be stated at the outset that the plaintiff claims that the whole video is defamatory, as a result of which she seeks damages arising from injury to her reputation and dignity. Ordinarily, defamation laws are aimed at protecting a person's right to unimpaired reputation and good name. Reputation is the reflection which the individual has in the eyes of the society. In case where the plaintiff extends her defamation claim to include damages for the violation of her dignity, the right for human dignity is entrenched in our Constitution, which provides that, open quote, Article 8, respect for human dignity. The dignity of all persons shall be inviolable, end of quote. Second, Eric. I think it's time for you. In motivating damages for defamation based on violation of dignity, Mr. Namanje referred the court to the following passage by Sachs J. in the South African Constitutional Court matter of Masetla versus President of South Africa and another, in as far as respect for one's career and reputation is concerned. Open court, paragraph 236. People live not by bread alone. Indeed, in the case of career functionaries, reputation and bread are often inseparable. End of quote. I endorse the above remarks, as one career and reputation more often than not brings bread to the table. Career, reputation, and bread are so entangled, in my view, that it is difficult to separate, just as the proverbial attempt to separate dissolved salt from water. Career and reputation not only define one's life, but one lives by his or her career and reputation. Article 5 of our Constitution sets the tone for the protection of fundamental rights and freedoms, including the protection for human dignity as follows. Open court. The fundamental rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, legislature, and judiciary, and all organs of the government and its agencies, and where applicable to them by all natural and legal persons in Namibia, and shall be enforceable by the courts in the manner hereinafter prescribed. End of quote. The South African court captured the value of dignity significantly in words that we historically and legally relate to. In the matter of Dawood and another versus the Minister of Home Affairs and others, Shalabi and another versus Minister of Home Affairs and others, Thomas and another versus Minister of Home Affairs and others, where the Constitutional Court said that, open court, the value of dignity in our constitutional framework cannot therefore be doubted. The Constitution asserts dignity to contradict our past, in which human dignity for black South Africans was routinely and cruelly denied. It asserts it too to inform the future, to invest in our democracy, respect for the intrinsic worth of all human beings. Human dignity therefore informs constitutional adjudication and interpretation at a range of levels. It is a value that informs the interpretation of many, possibly all, other rights. This court has already acknowledged the importance of the constitutional value of dignity in interpreting rights such as the right to equality, the right not to be punished in a cruel, inhuman, or degrading way, and the right to life. Human dignity is also a constitutional value that is of central significance in the limitation analysis. End of quote. It follows from the above constitutional provisions that where one It follows from the above constitutional provisions and interpretations that where one, through defamatory statement, his or her dignity is violated, such person may be awarded damages emanating from the said violation. This position, in my view, finds further support in Articles 25(3) and 4 of our Constitution. The training, working experience, and accolades of the plaintiff in this matter are not in dispute and are adorable by any standard. They are accolades which deserve to be celebrated. People must be encouraged to take pride and celebrate in the success of fellow citizens. And any attempts to tarnish the images of such persons must be rebuked in the strongest sense. As a matter of fact, the defendant stated on record that he has recently come to realize that the plaintiff is, in his own words, a good person who helps children and people in general, and that he would not want to trouble her. This cements the good reputation that the plaintiff has, which deserves protection. I dare say that even if the plaintiff did not possess all the accolades that she testified about, and that she was not a highly rated individual, her reputation will still demand protection. It is plaintiff's undisputed evidence that the content of the video recording injured her reputation, harmed her feelings and dignity. The allegations also affected her family, including children. The allegations of business assassination of Air Namibia harmed her. She testified that the defendant made the allegations out of pure malice for political reasons. It was evidence that it appeared that the allegations were aimed at the president and tarnished her in the process. This conclusion of the plaintiff finds corroboration in the dissection of the allegations of the video. In the first paragraph of the transcribed statement, as per paragraph 4 of the particulars of claim, the statement mentions the president that, open quote, when the president came to power, the very one who is under discussion here, end of quote. In the second paragraph, the statement reveals the sentence that, open quote, Hatukulipi is the one who supplied the president a spouse. How can you be connected by a woman as such to join you, a president and a thief, together? This demonstrates the fact that the video was aimed and directed at the president. And the plaintiff was casualty in the process. The plaintiff further testified undisputedly that the allegations made by the defendant were aggravated by the further statements made by the defendant after receiving summons when he publicly stated on social media that he was the first man ever to be sued by the First Lady of Namibia, if not in the whole world. Plaintiff further testified that a statement on the defendant's Facebook account that she must come if she wants me suggested that plaintiff wanted the defendant in a sexual manner. And this was hurtful. She was further hurt by the allegations that she was supplied like a commodity. Test for defamation: when one assesses the said defense of having made the allegations in the public interest in this matter, in particular where several admissions were made by the defendant, it is vital to bear in mind the test applicable to defamation cases. It is whether in the minds of a reasonable person the words used have the tendency to undermine or impair a person's good name and reputation in the community. This is a two-stage inquiry. First, what is natural or ordinary meaning of the statement? For this, neither the meaning which the maker of the statement intended to convey, nor the meaning given to it by the persons to whom it was published matters. So whether they believe it to be true, or whether they then thought less of the plaintiff, are irrelevant considerations. The test is objective. That how would a reasonable person of ordinary intelligence have understood the publication? Reasonable readers are not naive. They take into account not only what the words say, but also what they imply. Second, based on the statement's natural and ordinary meaning, would it tend to lower the claimant in the estimation of right-thinking members of society generally? With the test in mind, it is critical at this stage to point out the admissions made by the defendant in respect of the averments and evidence led by the plaintiff. They are as follows. 1, that he is a teacher at Ilao Primary School in the Ohangwena region and the regional mobilizer for IPC in the Ohangwena region. 2, that in February 2021, he recorded himself on video where he spoke in Oshuambo language, the words of which were soon translated into English language as stipulated in paragraph 4 of the particulars of claim. 3, after the recording of the video, he posted it on a WhatsApp group, a social media platform, without a caveat preventing further circulation of the video. 4, that the allegations made in the video that Mr. Atukulipi availed the plaintiff to the president for marriage, that plaintiff is a girlfriend to Mr. Atukulipi, and that they bore a child together, that Mr. Atukulipi is a friend to the president, that the plaintiff owns the airline West Air, that the plaintiff and others connived to bring out demise and liquidation of Air Namibia, that the plaintiff is a public official with influence on the decisions of the government, were based on alleged rumors that were circulating in the country, which he called national hearsay, thus unverified. 5, that the words mentioned in the video were made recklessly, and that had he been careful, the defendant would not have mentioned the allegations in the video. 6, that the words mentioned in the video could injure the reputation and dignity of the plaintiff. 7, that he was sorry for the allegations made in the video and asked for forgiveness from the plaintiff for the injury caused to her. Notwithstanding the above admissions, the defendant appears to be adamant that the allegations stated in the video were mentioned in the public interest due to the continuity of the reported ongoing state corruption. Can this be said to be a valid defense in law to the plaintiff's claim, I ask? The difficulty that the defendant finds himself in is that he did not care about the possible harm that his video would cause to the plaintiff. His evidence that he relied on rumors offers him no shelter. It has been argued that it is better to repeat a rumor than to create it. Contrariwise, other protagonists argue that the one who repeats a rumor is worse off because he keeps unfounded allegations alive even beyond the life that the creator in his mind accorded to the rumor. This is a debate capable of lasting eternity and one that I'm not prepared to engage in. Suffice to state that in my view, there is no distinction on moral blamelessness on the creator of the rumor and the conveyor of the rumor. Both factions must be discouraged, and it must be known to everybody that whether you create the rumor or repeat it or simply say words capable of tarnishing one's reputation or dignity without a valid defense in law, it amounts to words spoken that carries the same liability. Caution to all and sundry, words have consequences. The statements made in the video are catchy to the people who come to have sight of it. They refer to the president being supplied with a wife by the wife's boyfriend, with whom she bore a child. The First Lady corruptly assassinating Air Namibia, the then airline of pride and the national treasure, and depict the plaintiff as a greedy and selfish person with no Namibian interest at heart. Yet, she is the mother of the nation. These remarks are like a rainbow. A person can hardly just glance once and ignore. To the contrary, they command a relook twice or even more. This is how tarnishing their vehemence are. Without beating about the bush, I hold without a phantom of difficulty or doubt that in the premises and that on the facts of this case, that the defendant failed to demonstrate in evidence that he indeed made the allegations in the public interest. Surfing through the evidence of the defendant reveals no valid defense in law to the plaintiff's claim. And such defense, therefore, falls by the wayside. The plaintiff testified in a forthright manner, clearly expressing the injuries sustained to her good reputation and dignity, together with that of her family, including children, thus establishing aggravated defamation. I find that the video recording was defamatory to the plaintiff and her family in the following respects. It stated that she owned and had an interest in West Air. She connivingly caused the demise of Air Namibia. It implied that she is corrupt, greedy, selfish, and only cares for her own economic interest, with zero interest in the Namibian people. It stated that she was a veil to the president as a wife, implying that she is a commodity incapable of exercising her own independent mind in deciding who to marry. It stated that she was a girlfriend to Mr. Tukulipi and they bore a child together, which is false and malicious. The video recording, which was politically motivated, is in the premises defamatory and injured the plaintiff in her good reputation, violated her dignity together with that of her family, including the children. I find that the plaintiff proved that she is entitled to damages for aggravated defamation based on both reputation and dignity. The difficult question to be addressed at this stage is the quantum of the damages to be awarded. The plaintiff contends that considering the aggravated defamation that the defendant is found liable for, damages in the amount of $350,000 Namibian dollars will be adequate. As expected, it is a mammoth task, even for the injured, to quantify the damages arising from a defamation claim. And the court is not better placed. A comparative study of similar cases is a useful tool to determine the appropriate award for damages arising from defamation. Masuku J. in Mbura versus Kachiri engaged in a comparative analysis of some of the defamation cases in our jurisdiction in the following manner. A. Amnyela versus Shanika. In this matter, the plaintiff, a litigant, was defamed by the defendant, a magistrate in open court. The defendant made various demeaning allegations against the plaintiff, inter alia that he was poor, stupid, and had sexual relations with a named individual. The plaintiff was therefore suspected of having contracted a certain disease by the magistrate. The court, after assessing the evidence, came to the view that the words were uttered in the presence of only a few persons and that the defendant had abused her position as a judicial officer. An award of 35,000 Namibian dollars was held by the court to be condoned. B. Unovene versus Nangolo. In this case, the defendant uttered statements at two separate political gatherings to the effect that the plaintiff's business was funded by stolen money, and that if he were to be asked where the money came from, he will be unable to provide an answer. The court, after taking the circumstances into account and previous awards, came to the conclusion that an award in the amount of 60,000 Namibian dollars was appropriate. C. Ngiwete versus Nekundi. In this case, the plaintiff, a permanent secretary in the Ministry of Foreign Affairs, attended a dinner on his minister's behalf at the invitation of the German ambassador. The defendant, a prominent member of the SWAPO Youth League, attacked the plaintiff at the press conference, alleging that the plaintiff had brought the country into disrepute by associating himself with certain German diplomats and with members of Namibia's opposition parties, which was untrue. The letter did not take the time to verify the correctness and accuracy of the information he disseminated. The court, after considering the facts of the matter, awarded the plaintiff an amount of $250,000 and further mulcted the defendant with punitive costs. D. Universal Church of the Kingdom of God, Incorporated Association Not for Gain versus Namzim Newspapers, trading as Southern Times. In this case, the defendant and newspaper published an article entitled "State Bans Satanic Sect." In another article in the same newspaper, the readers were informed that the Zambian chapter of the same church had been banned. The court was of the view that a reasonable reader would conclude that the latter article in question had a bearing on the plaintiff specifically. The court thus awarded the plaintiff an amount of $60,000 in damages. E. Trustco International and others versus Chikongo. In this matter, the appellant company, the proprietors of a newspaper, were sued for an article published by their newspaper to the effect that the mayor of Windhoek has been involved in an underhand land deal, which was described in the article as brother bond cartel. The Supreme Court on Appeal awarded the plaintiff an amount of $100,000, overturning an award of $175,000 granted by this court. The Supreme Court was of the considered view that the award by this court was extremely high in view of all the circumstances attended to the matter. Lastly, F. Ngimtina versus Trustco Group International Limited. In this matter, the plaintiff sued the defendant for an article published by its newspaper captioned "Ngimtina hijacks rural power plan to pamper in-laws." This court, after considering comparable awards and the circumstances of the case, awarded damages in the amount of $60,000 Namibian dollars. End of court. It is established that the comparison of cases is helpful in quantifying the damages from defamation. Useful as it may be, the comparison of cases cannot be used as a sole and conclusive measure to determine the award, as there is no mathematical formula in quantifying damages for defamation. Sachs J. in Dikoko versus Mokatla related to the difficulty that courts face when quantifying damages in defamation cases and said the following, open court: there is a further and deeper problem with damages awards in defamation cases. They measure something so intrinsic to human dignity as a person's reputation and honor as if these were marketplace commodities. Unlike businesses, honor is not quoted on the stock exchange. The true and lasting solace for the person wrongly injured is the vindication by the court of his or her reputation in the community. The greatest prize is to walk away with head high, knowing that even the traducer has acknowledged the injustice of the slur. There is something conceptually incongruous in attempting to establish a proportionate relationship between the vindication of reputation on the one hand and determining a sum of money as compensation on the other. The damaged reputation is either restored to what it was or it is not. It cannot be more restored by a higher award and less restored by a lower one. It is the judicial finding in favor of the integrity of the complainant that vindicates his or her reputation, not the amount of money he or she ends up being able to deposit in the bank, end of quote. In Muller versus South Africa Associated Newspapers and others, the court set out what must be taken into consideration in order to determine the quantum and said the following, open court. The character and status of the plaintiff, the nature of the words used, the effect that they are circulated, the effect that they are calculated to have upon him, the extent of the publication, the subsequent conduct of the defendant, and in particular his attempts and the effectiveness thereof to rectify harm done, end of quote. The plaintiff, the First Lady, is a public figure who has accomplished successes in the business field. She's a woman of independent thinking who led several companies and institutions. She has been engaged in projects aimed at poverty alleviation in Namibia. Her efforts have not gone unnoticed domestically in Namibia and internationally. Her good reputation deserves protection from being trampled on. Her dignity and that of her family is inviolable. The defendant, on the other hand, attempted to justify his defamatory statements during pleadings, which demonstrated further defamation with a conscience, clear as day, that the defamatory statements made were politically motivated. His motive was therefore to score cheap political points at the detriment of the plaintiff and her family. During the trial, with his back against the wall, the defendant still attempted to insinuate that the fact that he used the words "it seems" in the video should diminish his culpability, as it would appear to the reader that he had no backing information. I do not agree. The defendant only used the words "it seemed" in one of the sentences out of many. He mentioned all other statements as facts. And I harbor no doubt that the reasonable persons who watched the video understood the statements as emanating from a resourceful person, whereas in truth and in fact, the defendant was simply blowing hot air with no regard to the consequences of such statements. This is aggravating. The defendant did not produce the alleged apology posted on social media for the court to consider its content and his sincerity. He testified that he posted the said apology in the same way as he posted the defamatory video, as he had no idea that he could approach the First Lady, given her position. I find this statement not to be true. If the defendant could not approach the plaintiff in person, he was served with summons which revealed the particulars of the legal representatives of the plaintiff, but he failed to approach them. He was legally represented during the pre-trial stage, yet he made no attempts to apologize directly to the plaintiff or approach her legal representatives. His concession that the plaintiff's father and his father are close friends, and that he went as far as speaking to his father about this matter after the apology of the plaintiff to the defendant's father for intention to institute summons against the defendant. Rings to no intention to apologize. Why the defendant did not initiate through his father at the family level to the plaintiff or her father's an apology points to one direction: that he had no genuine intention to apologize for his actions, and this aggravates the defamation. For what it is worth, the defendant deserves a little bit of mercy for his apology expressed during the court proceedings. The weight of the said apology is minimal to the extent that it does not invite the court to treat the defendant with kid gloves. Even if such invitation will be said to exist, it will be an invitation I would comfortably reject. It is further aggravating that the defamatory statements were made by a leader in society, a teacher, and a political mobilizer who undoubtedly is looked up to by some of the members of the community. Leaders and educated persons, the defendant alike, should assist to breathe life in our Constitution by protecting fundamental rights and freedoms enshrined therein, inclusive of the respect for human dignity. Courts, while retaining the discretion in assessing the quantum to be awarded in defamation claims, further retains a wide discretion to be exercised judicially. As Damasep JP found in Deitunga versus Kabaongelwa, courts are conservative in their award in defamation cases. One of the rationales behind this is that people should not resort to instituting defamation claims as a means to make profit. It is difficult to quantify harm to reputation and dignity in monetary terms. And as stated, a higher award does not restore an injury to reputation and dignity. It is not necessarily the damages awarded that vindicates the injury caused to the reputation and dignity of the plaintiff, but the judicial decision in favor of the plaintiff. I find that aggravated defamation in this matter is befitting, with aggravated compensation to be awarded to the plaintiff. And the award shall accordingly reflect such aggravation. Turning to costs, it is a given that costs should be awarded to the successful party. The question is whether or not the court should award punitive costs on the scale of attorney and own client as prayed for. It should be pointed out that the defendant had and has no good reason to defend this action. Courts have decided that where the plaintiff has subjected the defendant to unnecessary trouble and expense, the court may, in the exercise of its discretion, order punitive costs on the scale of attorney and client. The difficulty in this matter from the genesis of the defense of the action up to the stage where the pre-trial order is that the defendant was represented by legal practitioners throughout the filing of the pleadings. The defendant, in closing arguments, suggested that some of the amendments set out in his plea did not originate from him, while others he could not recall if he provided related instructions to his erstwhile legal practitioners. The defendant, being a lay person at this stage of the proceedings, sought to bring to the attention of the court the content of the apology, which he allegedly tendered to the plaintiff during closing arguments, which was not allowed as the defense case within which the defendant could lead evidence was long closed, and with no application to reopen it before court. The apology would have or would have not had any bearing on the blameworthiness of the defendant. The defendant belatedly tendered an apology to the plaintiff in his closing arguments. The plaintiff was present in court during the entire proceedings. The unfortunate part of the defendant is that by the time that he apologized and sought forgiveness from the plaintiff had already testified, and there was no opportunity to hear her reaction to the said apology. Notwithstanding the belatedness, it cannot be said that the apology tendered is of no moment, It will, however, carry very little weight, but it is weighty enough to tilt the scales of justice in his favor in as far as punitive costs are concerned. In further view of the fact that the defendant is a lay litigant, and considering the foregoing, I am, in the exercise of my discretion, not inclined to subject the defendant to further punishment in the form of punitive costs. I am of the respective view that the defendant has been punished enough and requires a measure of mercy even to a limited degree. I am therefore not persuaded that this is a case befitting of punitive costs. Consequently, costs will be awarded on the ordinary scale. In the result of the foregoing, I make the following order in favor of the plaintiff against the defendant. 1. The plaintiff's claim is granted for payment in the amount of 250,000 Namibian dollars. 2. Interest on the aforesaid amount of 250,000 Namibian dollars at the rate of 20% per annum, calculated from the date of judgment to the date of final payment. 3. The statements made by the defendant as quoted in paragraph 4 of the particulars of claim are hereby declared false and defamatory to the plaintiff. 5. 1, 2, 3, 4. 4. Okay, I'll repeat the order. 1. The plaintiff's claim is granted for payment in the amount of 250,000 Namibian dollars. 2. Interest on the aforesaid amount of 250,000 Namibian dollars at the rate of 20% per annum, calculated from the date of judgment to the date of final payment. 3. The statements made by the defendant as quoted in paragraph 4 of the particulars of claim are hereby declared false and defamatory to the plaintiff. 4. The defendant must unconditionally retract the statements quoted in paragraph 4 of the particulars of claim and unreservedly apologize to the plaintiff within 5 days of the date of this court order for the harm and damage occasioned by his defamatory statements. 5. Cost of suit. 6. The matter is regarded finalized and removed from the roll.
This is your lordship.
Yes, thank you. I'll attend to the typographical corrections and most probably upload the judgment during this afternoon.
As a court.
Thank you. That's the roll, then we adjourn.